Good evening, this is Rahul Reddy. Along with me is my business partner Emily Neiman. We are here to discuss every Tuesday immigration updates. Emily, I'm definitely updated on the priority date now. Is there, what's going on with the Trump administration?
It is so hard to keep up with all these changes. It's okay. Yeah.
So let's give what all the changes that occurred today.
Yeah, let's start with today.
Today.
We have two regulations that came out. These are final regulations. Skipped the notice and comment period. They're called interim final rules. Didn't even get reviewed by OMB. They just cut out everything. And so this impacts H-1Bs, H-1B1 for Singapore and Chile, E3.
L1s. L1s?
No L1s, just those that are filed with an LCA, and then it also impacts PERMs. So there are two different regulations. One comes from the Department of Labor, and that discusses new prevailing wages for LCAs and PERMs. And the other one is from the Department of Homeland Security, which discusses new regulations for H-1B. This is the one that we've expected for some time. We've known that they wanted to change the definition of specialty occupation, change the definition of employer-employee relationship, and basically make it harder to get an H-1B. So we know what's in that rule now, and it's going to take effect in about a little over 60 days. The Department of Labor one was a mystery because it wasn't even on the regulatory agenda. It just popped up at OMB a couple of weeks ago, and then it disappeared from OMB, and now all of a sudden we have a final regulation that is also going to take effect in a little over 60 days.
Well, immigration girl has forgot something. She probably didn't read all 147 pages that came out. The missing point, what she missed out, was that for consulting companies, there will not be any H-1B approval for more than 1 year.
That's in there. You missed it.
I missed it? Okay. Okay.
Yes, that is important. So it does specify
no,
that.
No, that's in there. That's what I was
No,
saying.
it's in Immigration Girl as well.
Oh, Immigration Girl, you had it. Okay.
Yes.
Well, this is my show. You're a guest there. You are the person. Okay. Yeah, that's so. Let's get to the bottom of it, Emily. Now, first thing is that let's say the prevailing wage in Houston for software developer, okay? I'm going to say that in Dallas-Fort Worth area, for software developer, the prevailing wage seems to be $76,000.
For level one.
Level one. So if some person were to file a H-1B right now, what would be the salary that they have to pay for the same H-1B position right now?
Yeah, so starting in 60 days, it looks like it's going to be closer to $110,000. The level one wage is going to be recalculated. Currently, level one is the 17th percentile of all the data. It is going to change to the 45th percentile, which is approximately the current level 3 wage. So entry level wage for an H-1B worker and for an EB2, EB3 PERM process, level 1 wage is going to jump to the 45th percentile, which is approximately the current level 3 wages, going, like you said, in Houston and Dallas here from about 75,000 to 100 to 110,000 to get an H-1B.
And what about the PERM regulations, Emily? Is that the same thing with the PERM?
Same thing for PERM, right.
Okay. Explain that. How is that when the regulations are supposed to be passed, don't we are supposed to get an advance notice? Don't we are supposed to be allowed to, aren't we supposed to allowed to comment, and then after that the regulations comes in?
Normally, yes, and we were all kind of surprised when they came out a couple months ago and said these were going forward as interim final rules. I'm sure that's partly election related. The Trump administration is trying to get all of these modifications out before the election to, make his base happy that he's being restrictive on immigration. So no, we skipped the notice and comment. We still can comment on these regulations that are actually taking effect, but they're going to take effect no matter what unless a court blocks them.
And Emily, it seems that in San Diego, the salary is actually $117,000, and everywhere the minimum seems to be, in major cities, even in a low-cost living cities like Houston, Dallas, which are not high cost, seems to be that the level 3 wage is almost like it's not less than 100,000. So if somebody is not making less than 100,000, you know, I mean, if they can't file a H-1B unless they make them more than 100,000.
Right.
And that's one thing. Then you said about the specialty occupation. We were already getting denials for the specialty occupation. Why is that now they need an extra knife in their hand to cut us? What is that they want to do?
So I think this one is not as big of an issue. It just specifies that to be considered a specialty occupation, the degree that you're saying is needed and that the beneficiary has to have needs to be directly related to the job. So they add that in throughout the definition of the 4 ways to prove specialty occupation, is that the degree has to be directly related. So they mention that degrees like business degrees and liberal arts degrees generally are not going to be considered directly related to any particular job and may not qualify.
How about MBA, Emily?
Yeah, exactly. I mean, there aren't a lot of jobs already, according to the Labor Department, that you have to have a business degree in order to do that job. So that one's going to be tough.
I also see that in this 147 pages, that when people are placing the people at the third-party location, though, there is an additional burden for the specialty occupation. They're going to consider the brochures and advertisements and different levels in addition to the regular H-1Bs for the specialty occupation.
Oh, I missed that part.
And what about the third-party placement? What was yesterday's rule and what is today's rule?
Yeah, there's 2 different areas where the third-party placement is impacted. Number 1, you'll only be able to get your H-1B approved for 1 year at a time. And number 2, you have to prove that the job is non-speculative, meaning that at the time you're filing, you have to have work lined up beginning on the start date that you're requesting, and we're back to providing end client letters, contracts, work orders, all the things that we used to have to provide under the new field memo are back again.
So 1 year, and then is there anything, fees went up for these people, for most of the consulting companies?
Well, that was blocked by the court, so
Okay.
as of this moment, the fees are the same.
Okay, so if the court takes the block off, every year the companies have to shell minimum of $4,500 just the filing fees,
Right.
and plus the legal fees and other administrative expenditure that is involved in it. What are the chances for this one, for the court to block it, Emily? I know I already had discussion with interested parties on the litigation part. What do you think the court is?
I mean, I do think there are good chances for litigation to successfully, at least preliminarily, enjoin these from taking place. So that means while we're waiting on a decision from the court is going to say, we're not going to allow you to actually implement these rules because we need to go through the court process, and we think that the people bringing the lawsuit are likely to win. I think there's a couple of reasons why litigation is possibly going to be successful. Number 1 is this is done as an interim final rule. The public did not have a chance to comment on either of these, and the reasons that both of the agencies gave for skipping the notice and comment are kind of flimsy. Number 1, they're saying blaming everything on COVID-19, yet they're saying that U.S. workers have been harmed for the last 20 years by these policies, but all of a sudden we only need to fix it because of COVID-19. And then the other reason that I think that it's possible to get these blocked is that, you know, the director of DHS is still not he wasn't validly confirmed. And that is one of the main reasons that the fee increase didn't take effect, because the court found that he really didn't have the authority to implement that fee increase, among other things. So for those 2 reasons, I do think that litigation may be successful in blocking these from taking effect.
Already I discussed with some of the companies, and they're pulling up the money to litigate this case, Emily. Any other updates that you want to give, Emily?
Let's see. Yeah, in the H-1B rule, they add a little bit more, and I didn't mention this on the blog on Immigration Girl, but more teeth to the site visits. So a lot of, especially third-party placement, have already been seeing site visits for some time under that program. Now it kind of gives some extra authority to USCIS to take negative action and possibly revoke or deny applications if the individuals that are subject of the site visit are not in compliance or are not willing to cooperate with the site visit even. So there's some additional things to be concerned about there if you have a site visit happening.
And any updates on the, for those people who are interested in about Downgrade, last week we presented everything in Downgrade. We want you to watch the Downgrade thing for last week, and especially there's a term called marriage that I used. Now, if you follow that, you will be concluding to a very good, and if you understand what that marriage in the sense that I said last week with me and Emily has presented, most of the people got the idea very clearly. So any Downgrade questions, please go back to our video last week and you will get most of the answers. Emily, you want to go to question and answers?
Sure. I don't remember. Did we even talk about the premium processing last week with
Yes.
all of the different types of premium that are expected to become available?
Yeah, I don't think so. We did.
Okay, so that was one thing that was part of the omnibus spending bill, the budget that was passed recently to continue to fund the government for the next few months. It included several of the provisions from the USCIS Stabilization Act, which was basically meant to provide more fees to USCIS so that they can properly operate. So they do this through expanding premium processing in a couple of ways. Number one, for petitions that currently allow premium processing, they are increasing that fee from $1,440 to $2,500. So an H-1B premium processing is going to be $2,500. L1, I-140s that qualify for that. That has not been implemented yet, but that was specifically passed in this statute, so it should be coming. On top of that, Congress specified that they want USCIS to expand the types of applications that can do premium processing. This will be a great benefit for a lot of people because it will include EB1C I-140s, which currently don't have that option, change of status to F1, H4 extensions, all those I-539 applications that are stuck because of biometrics, you'll have the option of premium, and EAD extensions will have the option of premium. Now, all these new things, though, have to be implemented by regulation, which means they have to go through notice and comment. USCIS has to actually set the fees that they want to do. The bill says this is the maximum fee, and it sets the maximum amount of time USCIS can take to adjudicate these applications, but USCIS has to decide on the nitty-gritty actual amounts for those. So that will take time. So if you're stuck with a H4 L2 extension pending forever because of biometrics and all of that problem, this rule probably won't help you right now, but maybe next time around when it's time to file an extension, you'll be able to benefit. But it is going to be very expensive if you're filing an H1 extension in premium, H4 extension in premium, and an EAD extension in premium. That's thousands of dollars of filing fees that you'll be forced to pay just to get a basic service. So, I'm not a super fan of that because it doesn't do anything to correct current processing times. It does specify that current processing times can't get worse, but it doesn't do anything to improve them so that people don't have to file in premium processing for everything.
Kapil from YouTube has this question. You announced all the bad news. Is there any F1 rule changing about the duration of status? Kapil, that is in the proposals right now. It's not yet passed. But yeah, that's going to be very dangerous if that rule comes out. Every time you change the university, you have to go to the USCIS and get the approval. And as Emily was pointing out, you may have to pay the premium processing every time when you change the university. Or you may have to file an I-539 every time you file a OPT, STEM extension. That's going to be a nightmare, though, if that rule goes through. This seems to be like a very restricted government. I hope, the next government will come and hopefully, undo all these regulations, Emily. That's the only hope that I have.
Yeah. Amarnath from Facebook has an H-1B approval with one company that's effective from October 1st and wants to know if that can be transferred to a different employer without ever joining that first company. So I'm assuming that this was a change of status that was approved and took effect on October 1st. So beginning October 1st, if you're not working for that company, you can consider yourself in the H-1B 60-day grace period, and you need to file a transfer within 60 days of October 1st. If you do that, then you possibly could get that transfer approved without having the pay stubs from that first employer. We were able to do that a number of times last year due to similar situations.
Now, the chances of the duration of status to go through this in this administration is very high. There is a very good chance that it's going to go through. Emily, we forgot about speaking about the court order on the travel ban.
Oh yeah, I'll let you go on that one.
Yes, it's too many things going on. The court is coming in our favor. The administration definitely doesn't want us. The court, can you explain anything about the travel ban? What's going on with the travel ban?
Yeah, so we have, this is the H1 and L1 travel ban that was issued several months ago. There were a number of lawsuits filed, some of them not as successful, but this particular one was by the Chamber of Commerce, and this was in California, and the court agreed that the travel ban basically made no sense. The reason behind the travel ban wasn't really in line with the steps the government took to block people from coming into the U.S. Now, with this particular case, the injunction that blocks the travel ban from taking effect is only for the people included in the lawsuit, which would basically be employers that are members of that Chamber of Commerce or other employers that were specifically named plaintiffs in the lawsuit. So it does not benefit everyone. It is a step in the right direction. We still have the problem of, even if you're not subject to the travel ban, how do you get an appointment? There's just no appointments available. People can't get the emergency appointments. They just get these boilerplate email responses. No one's getting through.
There are a lot of questions coming on the adjustment of status, obviously, and one of the main questions are birth certificates, especially. By the way, guys, I'm a lawyer in India, licensed lawyer in India too. I know how the things work in India. So let me give you some common tips right now to file the adjustment of status. You just need to file the adjustment of status. If you have any deficiency in the birth certificate, your name is wrong, I don't want you to submit that one. If by any chance the date, anything is misspelled in the date, don't submit it. If your father's name or mother's name is not spelled entirely, it's okay to submit the birth certificate. If your first name is there but full name is not there, it's okay to submit the birth certificate. If your entire name is missing on your birth certificate, you don't submit that at this point of time. Just submit 2 affidavits. The draft of those 2 affidavits are at rnlawgroup.com. You type in, search for birth affidavit. We have given a format where you can use those things. It will tell you to get a lot of other documents. You can't get it in this short period of time. So just get the birth affidavits. Where do I get the birth certificates? You can get it from family, friends. Do they need to be 18 years old when you were born? No, they don't need to be 18 years old when you're born. They need to be 18 right now. So get 2 affidavits. You don't have to go to India to get the affidavits. These affidavits need to be notarized, so you can get it done here in United States. Some of your family friends can give it. That's going to be easier for you to get the birth affidavits. I'm going to do a separate session, maybe 10-minute session, only on the birth certificates in November. Now, I will tell you what kind of RFEs may come in, how to answer, and all those things in that particular thing. Right now, I just want you to file the adjustment of status. I can tell you one thing though, that I have been practicing immigration law for 25 years. If there is anything that, but because of the birth certificate, did anybody get denied? I have not seen it. I've not seen it. There are ways to prove that you are who you are other than the birth certificate, believe me. They can be implemented, they can be used to get in. There are so many alternatives. I know you are alive. I am guaranteeing you're alive. And there are ways to prove it other than me saying that you're alive. So there are ways, don't worry about it right now. Any deficiency, just file, get affidavits. Other question that comes is, oh, I was born in 1982, and right, but I got my birth certificate in 2020. It's okay, submit the birth certificate, you're good. If they ask any questions at a later date, you can answer it. Right now, you can submit the birth affidavit.
Kanda Reddy from YouTube recently got his EB2 PERM approved, and his country of birth is India, and wants to know if he can file the I-140 in EB3 instead of EB2, and is this considered a downgrade? Yes, pretty much every EB2 PERM can qualify for either EB2 or EB3, so whichever one provides you greater benefit in terms of processing for the green card, you can file it in that category. It's not considered a downgrade. A downgrade is when you already have an approved I-140 based on an existing labor, and you are refiling an I-140 using that same labor in a different category that's lower. This is not a downgrade. You haven't filed an I-140 based on this PERM yet.
Johnny from YouTube has this question. Indian-based MNC not downgrading from EB2 to EB3. Do the employees have the right to ask, or do they have the employees have right to go to court? You can always ask, but you don't have. I don't think so. You have any rights to go to court. I mean, you are not going to win if you go to courts. So it's at their mercy. There is nothing you can do about it if they don't want to file it.
Arvin wants to know if I can do a H-1B transfer when an H-1B amendment is in progress. Generally, that's fine as long as it's not an amendment plus extension to where your I-94 is already expired. You just use the underlying approved petition and file a transfer based on that, and not had any issues with that, assuming that you've maintained your status with the prior company through that amendment. Probably wants to know if the prevailing wage rule impacts already approved petitions. Good question. If you have a H-1B petition, E3, H-1B1 that's already approved, this rule does not impact your currently approved petition. It will impact your next petition. If you have an LCA that's already approved, it will not impact your current LCA. It remains valid. Those wages stay the same. It will impact your next LCA.
What about the PERM?
I'm getting there. If you're filing your LCA, the filing date after this rule takes effect, then it will impact those LCAs. For prevailing wages for the PERM, if you've already received your prevailing wage determination, it remains valid, it's not impacted. If you've already filed your PERM, it remains valid, it's not impacted. If you've already gotten your PERM approved, it's not impacted. Where it does impact is if you have a pending prevailing wage request that's still pending 60 days from now. The new rule will be applied to your pending prevailing wage request.
A lot of questions on the premium process. We did cover those things. One major question, does the HEROES Act, which prohibits the GC spillover, will it have any impact on the people that are filing, that are intending to file? First thing is that that bill to go through Senate, it has two, the US Parliament has two houses. One is House of Representatives, one is Senate. They call both of them combinedly here in the United States as Congress, and the rest of the world we call it as a Parliament. So there are two houses in there. The chances for this bill to go through Senate looks absolutely nil. I would rather bet on Senate 386 bill to go through rather than this bill going through the Senate. So I'm not giving that importance to it, where they are blocking the green card for a spillover.
Depeche has already filed his adjustment of status on October 1st, so that's great. However, the version of the I-765 that was submitted is an old version. They did update that recently. He wants to know what will happen. That I-765 portion of your application will be rejected. They won't accept the old version of the form, so you'll get that back in the mail maybe a month from now, maybe even longer because of all the craziness that's about to happen at USCIS. So you'll have to refile it after you have your 485 receipt notice.
Emily, is there a premium processing for the adjustment of status or 485? Is there a proposal?
No proposal
no
for
proposal
it,
at all.
nope.
No proposal at all. I wish it was there. That would be the ultimate thing I would like to have it. All other things, if I get a premium processing and adjustment of status, I don't need EADs, I don't need anything, I'll be good. I hope that will go. But there is no proposal at this point of time. There are a lot of things that they have to check before they get it. Right now, the processing time for the adjustment of status is about 36 months, guys. A lot of people are asking, should I file the medical thing? We are advising people not to, because medicals expire in 2 years and the processing time is 36 months. And there is another problem with all of you guys. You guys are not current, the ones which intending to file in October. It's only the filing dates are current. What does that mean is that even if they reach the processing time, they cannot technically give you the green card unless the final action date is current. You can file but not get the green card. So I don't know why we have to send the medicals right now. You could send it later on. I would not propose. Even if you send right now, if processing time is more than 36 months, after 24 months it expires. So no purpose for you to do the medicals.
Nayak from YouTube, the spouse has another 5 years left on her H-1B. She hasn't gone for stamping and have not gone out of the country. Wants to know if she should switch to the EAD and AP after the 485 is filed or continue on the H-1B. A couple things to consider. Number one is if this is a downgrade situation where you are trying to use the EB3 dates and want the ability to go back to EB2 in the future, in case that becomes preferable, it's best that she remain on H-1B so that she can file another 485 once that date becomes current. And then in general, if you let your underlying non-immigrant status, such as an H-1B or an H-4 or L-1, lapse while your 485 is pending, if for some reason something goes wrong with your 485 and it ultimately gets denied, and you're no longer maintaining your underlying status, that denial puts you immediately out of status. Unlawful presence starts immediately, and if you don't exit the country within 30 days, they can initiate deportation proceedings. So for that reason, a lot of people do prefer to maintain their underlying non-immigrant status, even though it's not mandatory, just to have that fallback position in case something goes wrong with the 485.
Mahir has this question. After filing 485, can I transfer the H-1B? Will it cause any problem if I move from one company to another company? You can transfer the H-1B after filing adjustment of status. However, after 180 days, you also need to file something called 485J supplement. If you don't file the 485J supplement though, the 485 may become invalid. So you need to do both the things, H-1B and 485J supplement, to move from one company to another company.
Minish from YouTube wants to know if we need to disclose a traffic citation in the 485. So you can actually go to the 485 instructions and use the handy Control F to find the word traffic, and it sets out exactly what type of traffic ticket does not have to be disclosed and what does. Generally, there's a specific amount for the fine. If it's under that amount, you don't have to disclose it unless it's involving alcohol or driving under the influence or something like that.
Yeah, if you have a DUI, definitely you need to. If it's a simple traffic ticket, but simple traffic ticket where you're speeding 10 miles and there's no arrest involved, and sometimes in traffic tickets also police can arrest people though. That definitely, if you're arrested, you need to mention. But simple traffic tickets, red light, or parking violations, if I were you, I would not. But anything DUI, any accident involving those things, definitely you may have to report it. DUI for sure you have to report it.
Nitin from YouTube wants to know, so if he's getting paid $75,000 now per year with a level 1 wage, will he have to be paid $100,000 with the new regulation? basically, yes, assuming that when you file your extension, you're still at a level 1 wage entry level job, they will expect that the higher, the new prevailing wage will take effect, and that's going to be about what's currently level 3. So if you're at 75, you're looking at closer to 100,000 by that point.
What was the Alabama city that you said it's 95,000?
Oh, Montgomery. It went from 58,000 to 95,000.
Okay, yeah. If you go to some small remote areas, though, that prevailing wage may be a little bit lower. But if you go to San Jose, San Francisco, or any of those areas, the prevailing wage will be very, very high. Vislet from YouTube has this question. Is it fine to apply the green card? What I mean, he probably meant to say is PERM application and I-140 green card while on F1 and STEM OPT. Absolutely yes. We strongly recommend that if you don't belong to India and China, your priority dates most probably are going to be current. Why go through the expensive process of H-1B? Directly go to the green card, boom, you got it. That can be easily achieved bypassing the H-1B. That's what we do for a lot of people.
Tejaswi from YouTube wants to know, the previous employer is not providing an experience letter. Is there anything that we can do to get that experience letter? So you do have some other options, and I actually have a blog post about this if you go to immigrationgirl.com and look for experience letters. If you're not able to obtain the experience letters, you can document it through affidavits from former coworkers that can attest to your work and the dates you worked and what your job duties were, plus your pay stubs or W-2s from those years. An offer letter can be a secondary evidence. So yes, you can potentially still proceed with the process even if you can't get an experience letter from an uncooperative employer.
944 questions. Does stimulus check qualify for the public benefit? No, it does not. It is not a public benefit. Does the low score of the credit score, will it have any impact on getting the green card? That by itself is not a whole reason for you to get the denial. Typically, if your family income is less than $60,000 and your credit score is lower though, then I would say that it may, but I'm assuming since you're filing an adjustment of status and employment based, your family income is higher, so it should not affect the credit score. So credit score should not affect. I will say that my credit score and Emily's credit score are very poor for whatever reasons. Now we don't have loans, but it's just for those people who don't take the loans, their credit score is very low. You'll be very surprised that just because people have higher credit score doesn't mean that they're wealthy. And those people who don't take loans, namely I don't believe in taking loans, their credit score are much lower than other people. When I'm looking at the credit scores of my clients, I'm looking and wow, these credit scores are very high. Look at mine is very low. So it will not be the only thing to determine though.
Milind from Facebook also has a question about credit reports and credit scores. His spouse is the derivative or dependent applicant and does not actually have a credit report. This is quite common for kids especially, but also for spouses who've not worked in the U.S. or haven't needed to obtain an EAD or haven't obtained a credit card or any kind of loan. So typically they will want to see a letter or something from the credit agency showing that this person does not have a credit score or a credit report. In some cases in the past, I've just handwritten on the form that no credit score and submitted it that way. So generally they're looking for the main applicant to be the one that will have the credit score since you're the one working and all of that. Never had a problem so far.
Sandeep has a very interesting question. And there's another question that's followed. Dinesh doesn't have an interesting question. Sandeep is saying that his H-1B has expired, his extension has a receipt notice. Can he file an adjustment of status with the receipt notice, or does he need to have an approval? No, you don't need to have an approval. You can use the receipt notice to file the adjustment of status. Dinesh, does USCIS is going to increase its workforce to reduce the processing times? Wow, I don't believe this government is planning to do that at all. They want to increase the money, but definitely they don't have any intention of reducing the processing time, except in cases where the premium processing fees, it went up from 1,225 to, what is it, Emily, now?
2,500.
Sorry,
1,440 to 2,500.
2,500. And then they increase the limit of the amount of time that it's going to get the premium processing approved. So normally, you go to business class where you pay more money and then you get better seats and a better everything. Here, it's the other way around, is that from 1,400 to 2,500, you're actually getting at the back end. The whole intention of this administration is actually somehow, some way to get rid of all the H-1Bs. The only reason why they're unable to do it is because of the laws and regulations that are there, and now they amended the regulations. Laws can only come from the Congress. And the Congress is not willing to eliminate the H-1B program, but this administration, especially at the higher levels of where the administration has put all the people, they are completely anti-immigrants, anti-H-1B people. So those are the people who are passing these regulations, though.
Janani from Facebook wants to know about travel. Can the derivative applicant travel outside the U.S. after filing the 485 application? And spouse is on H4 at the moment. So if you're maintaining your H1B or H4 or L1 or L2 status in the U.S. right now at the time of filing, and at the time you leave, you're still maintaining that status, and you're going to come back in H4, yes, you can travel without abandoning the permanent resident application. So that's only for H and L, H1B, L1, and L2, and H4. But you have to be maintaining that status when you exit the country and come back in that same status. However, keep in mind there's going to be a biometrics appointment, so you have to make sure she doesn't miss her biometrics appointment while she's out of the country. And also, if you're filing an advance parole with your application, if you travel before that gets approved, the advance parole is going to be denied based on the current policy of this administration. So when you come back, it has to be refiled.
Collection account on my spouse, will it have any problem in the GC? If your family income is more than $60,000, I'm not expecting any problem for you. This is a good question from CB from YouTube. His EB1C is current right now, but it's not approved, it's pending. Should he file the adjustment of status, or should he wait until the I-140 is approved? Now, I'm going to tell you that if I were you, I would file the adjustment of status. You may lose the money if the I-140 is denied. Your 485 will be automatically denied. But the concept here is that now the priority date is backlogged most of the time. So when it's backlogged most of the time, for example, if you wait until I-140 gets approved, by the time your date backlogs, you are screwed up. And that's the reason why, if I were you, I would file the adjustment of status. Wow. One question is, Sunil Kumar has this question about the marriage we discussed, Emily. Mm-hmm. This is an interesting question. Is that I file an adjustment of status, H1 extension is still pending, H4 extension is still pending, the driving license is not given. Can I show the EAD to get the driving license?
Very good question. That's going to happen a lot.
Does that constitute a marriage?
No, thank goodness. That is totally fine. When we say marriage, that means you're using that EAD to actually work, or you're using the advance parole to come into the U.S. But using that EAD to get your driver's license renewed, to get your kids into school, I don't see any issues with that.
That's not considered as marriage. I want you to go back to last week's video so that you can understand what marriage means in the process of the EB3 downgrading and in the process of filing the adjustment of status.
On that same topic, Drusa from YouTube wants to know if one can work on the EAD at the same time and still maintain the H1B. So can you have the work over here using the H1B and work over there using the EAD? No. Once you use that EAD, you're no longer maintaining your H1, because the H1 only authorizes you to work for that one employer.
Now you're married to that.
Now you're married to that 485. So Puneet from Facebook wants to know what are the level 1, 2, and 3 prevailing wages.
What about the 17%?
Yeah, that's what I was going to
45%?
go through. So right now, so we have 4 prevailing wage levels, and currently, they do these surveys of employers to look at what are the lowest paid people in that location and the highest paid people in that location, and then they do a bell curve distribution and figure out what to set the 4 wage levels. So currently, level 1 is the 17th percentile. Level 2 is the 34th, level 3 is the 50th, and level 4 is the 67th percentile. Going forward, it's going to change. Level 1 is going from 17th to 45th, which means it's going to be closer to what the current level 3 is. And level 4 is going from 67th to 95th. So if you're a level 4 wage right now, your wage requirement is going to go way up from 67th percentile to 95th percentile, and then 2 and 3 are going to be between that 45th and 95th percentile.
Question here about the
Rupian wants to know if the new rules have any impact on the I-140 processing. So no, it only impacts LCAs that are filed after the rule takes effect, and PERM applications where the prevailing wage is pending or filed after this regulation takes effect. So if you already have your PERM approved, you filed the I-140, the new wages do not impact you.
Sriram has this question: what happens if on 485 application I'm there and I lose the job? If you lose the job after the I-140 is approved and after the 485 has been there for 180 days, you can actually go to next employer and get them file the 485J supplement. But if you don't have any job at all, whatsoever at all, then the 485 is expected to be denied because you don't have a job. The whole criteria for it is that you continue maintaining the employment opportunity that you have in United States in the similar field. So if you meet that, you'll be fine.
Sharif wants to know when the November visa bulletin will be posted, and do we think priority dates will continue to move forward? So the last couple of months, the visa bulletin has been issued later and later. This last one was really late. I think the latest it's ever been, which was the 25th. So we may not find out until the very last week of October if the dates move at all, the final action dates, and also we may not find out until the last week of October whether we can continue to use the filing dates chart. So generally with these two charts, the filing dates chart, the one that everyone's filing under right now because it's very far advanced, generally only changes in October. That chart is not expected to advance or retrogress. It might, but it generally doesn't over the next 12 months. It's the final action date chart. That one will move slowly forward until it meets the filing date chart, which should happen at the end of this fiscal year, a year from now, if their predictions are accurate. But they can't predict how many people are downgrading and how that's going to impact the EB2 and EB3 situation.
A lot of questions on the downgrade and the adjustment of status, especially in the public charge information. I have less money in the bank. Will it cause any problem? If you have family income is more than 60,000, you should not have any problem even. I have a lot of loans on my house and credit card. Same answer. If your family income is more than 60,000, that's fine. Yeah, if it leads to maybe 10 million or something, your loan, that doesn't look good. But if your family income is 60,000, you have a loans, your net assets are, let's say minus 500,000, that still should be fine. I mean, should not cause much problem when you're getting the green card.
Sandeep from YouTube is getting ready to file the I-485 application, but his H-1B actually recently expired in September, and the extension is still in progress. He wants to know if he can still go ahead with filing the green card if it's going to create any issues. So for employment-based green cards, to be eligible to adjust status, you need to have maintained your underlying non-immigrant status to at least 6 months before you're filing the adjustment of status. So if your I-94 expired just 1 month ago, technically you're still eligible to file the adjustment of status, even if you hadn't filed the extension. Now, I'm not recommending anyone to do that. So not having the extension approved does not mean you can't file the 485. You can still file it. And then you'll be able to provide, hopefully, your H-1 approval notice for the extension at the time of the interview. Same idea. I'm getting a lot of questions about spouses having that issue because of all the biometrics problems. People have H4s and L2s that expired more than 6 months ago and are still pending on the renewal. That is a slight risk situation because your I-94 expired more than 6 months ago. You don't fall into that 6-month window for filing your adjustment of status. However, you can still proceed to file it because it's very likely that your extension is ultimately going to be approved. I'm assuming at this point the main applicant, H1 or L1 holder, already got their extension approved. So assuming your extension was properly filed and timely filed, it's not likely that you're going to get it denied, which means you'll get it approved at some point and your 485 will not be impacted.
Question coming, does the interim rule applies to the MNC companies from India? Yes, they do. They will be very severely affected. They will be severely affected for many different reasons. One, most of them are third-party placement. The second is that short-term extension and specialty occupation has also become a little bit tougher with this new regulation. So yes, that's going to affect a lot some of these companies though.
Question from Murali on YouTube. He wants to know, once we file the 485, E80, and AP and they're pending, what if we want to travel outside the U.S. on H1 and need to go for stamping? Is there any issue with getting the visa stamp for an H1 or an H4 because you've got these applications pending? So for both H1, H4, L1, and L2, these are all dual intent visas, meaning you can have the intention of becoming a permanent resident and also qualify for that type of visa. So simply because you have those pending should not have any negative impact on your ability to get the visa stamp, assuming you can get an appointment.
Yes, can I submit my appraisal on home as a home value? You can do that. There is another easy way, guys, to submit any evidence of your financial things. One thing is that you can go to Zillow.com and type in your address. The value of your address comes in. Print that. That's more than enough, guys. I mean, I'm not going to get an appraiser appraise my home and then submit it. That's going to cost money and time. It's not needed for this one. If they want to, they can issue an RFE, and then at that point of time, we can go to an appraiser. But for just filing this adjustment of status, if your family income is more than $60,000, I would not go to an appraiser.
Hardik from Facebook wants to know if there are any implications of the new H-1B rules and prevailing wages on healthcare workers or Schedule A workers. Yes, they do apply. So the new prevailing wages will apply. Whether you're a healthcare worker or a Schedule A worker. And the H-1B rules regarding third-party placement could be an issue in healthcare, especially if you work for a staffing company where you're placed at a third-party site. You may be getting short approvals valid only for 1 year.
What about teachers, Emily?
Yeah, very possible if they're through a staffing company. But as far as the wages...
So if they're working for a direct company, though, still the wages are increased from level 1 to almost level 3 right now. Most of these teachers, they don't get level 3 salaries, though. So even if it's an entry-level job, though, they have to be paid at level 3, and that means that all the teachers will be kicked out of the country.
Yeah, I mean, that's the whole purpose of this. They expect these rules are going to impact 1/3 of all H-1Bs.
Really?
That's what Cuccinelli said today in his tweet.
So they want to eliminate 1/3 of the entire H-1B force.
That's exactly
from the
what
United
the
States
purpose is, yep.
That's going to be major. I sympathize with especially teaching profession. Unlike IT, which some of the people may be fine, but the teaching profession is very hard under these new rules, though.
Niraj from YouTube wants to know, he's about to file the AOS and his father's last name is missing on the last page of his passport. Do not worry about it. Names on the passport for parents are not an issue. They're going to look at your birth certificate.
Can PERM be questioned during a downgrade as my university does not exist now? Well, it has to exist at the time when you graduated though. If it doesn't exist right now, it's not a problem unless there is some fundamental issue with the accreditation of the university, then there may be an issue. But if it's an accredited and a proper university at the time when you graduated, it doesn't matter afterwards whether the university exists or not now.
Vikram from YouTube wants to know, if I downgrade to EB3, when will I get the EAD? Is it only after the I-140 approval? No, the EAD is based on the fact that you have filed a employment-based adjustment of status. It has nothing to do with the I-140 processing. However, go back and watch what we talked about last week. If you're doing a downgrade, we're generally recommending that you not use the EAD because then you're going to be married to EB3 and won't have the option of going back to EB2 later.
One other question, especially for the kids who are nearing 21, we don't want the kid to be married to EB3. And I'm wanting to go back for you last week to see what does that means by marriage. We don't want kid to be married to EB3 who is coming near to 21 years, especially if they are anywhere after 15 or 16 years old. The kid should maintain the independent status until the final action date becomes current. We will discuss more on that probably in December or so. We'll come up with a video about just we will call it as age out kids. When the age freezes, when they are fine, when they are safe, we'll come out with a video in November or December.
Soccer Hero from YouTube wants to know, what happens if I file the I-140 and 485 with a downgrade to EB3 and the I-140 gets denied after 180 days? Well, the 180 days is irrelevant. Once the I-140 is denied, it's going to cause your 485 to be automatically denied. So if you are in a situation where your downgrade is particularly risky, maybe there's an ability to pay problem, you need to make sure you don't get married to that EB3. Don't use the EAD, don't use the AP, continue to maintain your non-immigrant status.
Srini has a very legal question. What will happen if the travel family ban is lifted? Will the numbers given to the immigrants, employment-based immigrants, will they go back to family? The extra green cards that we got it were based on the 2020 base, so they're not based on 2021. So that we already got it. I mean, the employment-based people already got it. The only way to undo it is to going through the Congress, through the Parliament here, which looks very unlikely that the Congress will do anything on that. But with regards to the 2021, as of now, the family ban is only until December of 2020. But they're still covering the 2 months period. The judge actually took the ban off right now. So, but still, because of the COVID, there are a lot of restrictions of getting the visa. So the excess green cards, they may consume it in the 2021 itself because they still have 10 months to cover it and give the extra green cards within that particular year. But this year green cards, that means the 2020 green cards, 2020 after immigration ends on September 30th, is already given. It's ours now. It can't go back to the family immigration unless the Parliament or the Congress here changes any law. It's ours. It is not going to go back.
Aditi from YouTube wants to know, if you're laid off while you have the 485 pending with an EAD, what is the grace period to find a new job? There technically is no grace period. You have to have a new job offer in place to be ready to submit a Supplement J with that new job offer. Anytime you get a request for evidence where USCIS asks for it, and in time for your interview. But there's no specific grace period like you have on H-1B.
Can a company file H-1B I-140 in EB3 and I-485 together? Yes, they can file all of those things. Normally, the I-140 and 485 will club together, but the H-1B goes to a different address. But they can file both the things at the same time. I don't see any problem in that.
Ritesh from Facebook wants to know if you can transfer a pending 485 to a spouse's I-140 if the spouse's date becomes current. No. So if you don't get married to your pending 485, then when your spouse's date becomes current, you can both file another 485, this time with your spouse as the primary and you as the derivative. So you would basically each have two 485s pending. No problem with that, as long as everything's consistent and the prior 485 is disclosed. Then when whichever one happens to be faster is ready to be approved, USCIS will usually ask you to withdraw the other one. Have you ever had any issues when someone had two 485s pending for the same person?
What happens, Emily, is that when I go to the interview, though, the officer or sometimes what officer sends an email or kind of RFE, but sometimes I even have officer call me on the phone and tell me, hey, Rahul, why don't you do one thing? Why don't you withdraw? I'm about to approve this one, but I have two applications pending. Can you have your client withdraw this one? I'm going to approve it. I normally approve. Sometimes when they go for an interview only, the officer clears all the things and say, I'm going to approve this guy. Can you request him to withdraw that one? Sometimes that happens, especially when you're coming near to the green card. But maintaining two adjustment of status is not a problem.
Yeah, and I'm hearing from a lot of people that they're being told otherwise, that if you have two, it might be considered fraud and it's very risky, and that's just not true at all.
Not true. Many times I had filed a two adjustment of status. Sometimes in the employment based, it's pending and the date's backlogged and the girl got married. And she was still meeting the H-1B. She wasn't married to the adjustment of status at that time. So I filed a family-based green card, and when I went for the interview, they practically made her, withdraw the employment-based and gave her the green card. That happens many times. I mean, there's nothing wrong with it to have two adjustment of status pending.
Barani from YouTube wants to know if it's mandatory to have the end client letter when filing an H-1B extension. So beginning 2 months from now, yes, that will be mandatory under this new regulation that was published today, assuming that a court does not block it by the time it takes effect.
At 6 o'clock, anything else?
I think we've covered enough for today. It's hard to keep up with all of these things.
New laws are becoming, they're coming in the past, especially 10, 15 days, so many new things. But we will educate you guys, and being a non-immigrant people and staying in the United States, it's good for you guys to tune in to our thing. We bring in every week, we present as much as possible and answer your questions. Please, like us in the Facebook and also subscribe to our news channels so that you get the news as it happens, because we bring directly, we are not mediators, we bring the news directly, what it is.
Thanks for joining.